Mr Speaker.
The Honourable Amy Adams.
Mr Speaker, I move that the Returning Offenders Management and Information Bill be now read a second time. Mr Speaker, in this slightly unusual situation where we're having the second reading immediately following on from the first reading, I don't propose to do what I would normally do in a second reading and go through in some detail a number of the matters that I set out in my first reading contribution. Instead, what I want to do is take the time to expand further on some of the rationale for the structure of the bill, the way it will operate, to provide the House and anyone following this debate with a little bit more context around that. And then I do want to touch on some of the allegations that have been made around what is perceived as delay, and I can assure the House that there absolutely has not been. So if we start with the operation of the bill, and I've said in my first reading contribution, the bill is about trying to replicate as closely as possible, and I don't pretend that it's an exact replication, the sort of supervision and management of offenders that they would likely have been subject to if they had served the same sentence in New Zealand. And the reason it isn't an exact fit, and the reason that it has been very complex to work through these policy matters, is because, of course, you're dealing with a regime that needs to apply in a blanket way and yet be very careful to not traverse unfairly on the rights and the provisions of natural justice and the rule of law in respect of the returning offenders, have the right sort of oversight in place, but also provide the flexibility to seek additional specific conditions when that's needed, and in the absence of the mechanism that is normally used in New Zealand, which is the parole board. So it's very easy, I think, at this stage, when all that work has been done, to look at the framework and say, well, you know, could have banged that out sooner. But the reality is that not only were we having to spend far too long negotiating with Australia to get the right information so we could assess the type of people coming back, the risk profile, the sort of information which anyone who has been a minister will understand you absolutely must have before you can work through any of the processes the Cabinet Manual requires around quantification of the impact of the changes you're proposing, the cost of them, making sure we had the budgetary provisions in the Cabinet paper to make sure it was adequately resourced, and getting all of the appropriate components that you have to be able to certify as a minister when you're bringing proposals for a new policy to Cabinet and then to this House. Now, to do all of that, as I say, it was a matter of working with corrections and with police, but they really couldn't even begin to do their work until Australia had stepped up and provided us with this information. And I've said publicly, and I'll say it here again in the House, I am disappointed that we, as a close neighbour and for a long time close friend of Australia, found ourselves in the position when the impact on New Zealand was brought to my attention first in February of this year. What that meant was that New Zealand found itself starting from a completely cold start once the law was already in operation. That is not ideal. That is not the way that we expect to deal with Australia, but that is the position we were in. That was the position I was in, and I think we responded in the absolutely timely way. My officials have confirmed that the first advice that ever came in front of me, it was certainly not mentioned in the BIM, it wasn't mentioned in any briefings at the time. The first advice that came to me was February, 12th of February, and at that point I instructed them to begin work immediately on this framework. The suggestion that some members of this House have made that somehow that's just all a bit of sort of precursor fluff and the work actually starts when you start drafting, I think reflects a lack of understanding of the process. Drafting is the end of the process. And I want to commend and pick up on the comments that my colleague Chris Bishop made when he commented on the Section 7, the Bora report by the Attorney-General. And I mean, I would say this, but I think he's absolutely right. These are issues that could so easily have traversed Bill of Rights issues. These are issues that could have so easily gone one step too far in terms of Bill of Rights issues, or equally one step too light in terms of protection. And we have ensured that we did everything we could to land it in an appropriate place. And yes, the bill has continued to evolve, particularly with the news that came through to us in the last few days around this large number of offenders who are on their way back, where Australia have not given us advance notice, have not given us a lot of lead time with the information, and that information has been followed up on. Given that that is now a new development in the way these processes are flowing, and was certainly not mentioned in any of the briefings, we have continued to make sure that is as tightly provided for in the bill as we can. So I mentioned that the bill effectively replicates a parole framework. So what that means is if the offender, sorry, Mr. Speaker, certainly wouldn't be you, if the offender has been released if the offender has been released from custody in the overseas jurisdiction, and can I just get on record very clearly, while a lot of the debate is around Australia, and that is absolutely the source country for the vast majority of the people that this bill will touch, it is not the only country. This bill applies to anyone deported to New Zealand from any jurisdiction, so we just have to bear that in mind. But when the framework applies when the offender is released within 6 months of their return and released from custody. And that definition of in custody is very clearly also covers any time they spend in detention centres. Now, the reason for that is because what these conditions are about, whether they're applied in New Zealand or under this bill, is about helping to oversee the highest risk period for an offender, which is the time when they're first released from prison. And the longer they have been in prison, the harder that reintegration is, and so therefore the longer the monitoring tends to occur. It is not a punitive attack on the offender. It is about making sure that someone who has been in an institution and under very strict rules for a long period of time is carefully monitored and watched for offending behaviours and for the assistance they will require as they reintegrate. So if someone has served an offence in Australia, if it's Australia, and has been living and working and going about their business in Australia for some time, it wouldn't be appropriate to then turn around and impose those sorts of oversight conditions. If, however, they've only recently been released, then absolutely we need to be tracking that sort of behaviour. Mr. Speaker, the bill then goes on to provide that there's a recognition that while we have an automatically applying framework, some offenders will require a more directive, more restrictive set of conditions, and their offending will justify that. And in that case, the conclusions that I reached through that policy development process were that it would be quite inappropriate to try and provide for that in this legislation, and the risk of getting it wrong one way or the other was simply insurmountable. And so what the bill provides is that in that instance there are whole new powers to go to the district court and have the district court act in lieu of a parole board to make the case-by-case assessment as to when those additional, more restrictive conditions are required. And then the final piece is the collection of information, and I want to pick up on the comments Materia Ture was making in the first reading around the definition of identifying particulars, and we did have a good discussion for which I thank her on this point, and she had picked up a concern that I was also considering at that time, which was just saying, actually, had that gone too far? Had the information that the police had asked us to provide for, was it too much and that they didn't need it? And actually I felt that it was a fair point. We went back and looked at it and agreed that actually narrowing that down to the definition of the Policing Act was appropriate. But let's not cast aside how critical it is that we have that information. And there is every prospect that as offenders are returned to New Zealand and we get their biometric details and the like, there is every prospect that we might find some cold cases unsolved in New Zealand now resolved. Now, we don't know that, but I wouldn't be in the slightest bit surprised if that is the case, and it certainly means that that information will be held in the same way it would be if they had been served their sentence here. The last point I just want to make in this contribution is just really to inject a little bit of a calm note, I guess, into what has become at times, and not in this House, I think the debate has generally been reasonably constructive, but actually in some of the media commentary there has been almost a degree of hysteria. Let's remember that we release people from our prisons in New Zealand every single day. And these are people, whether they've served their sentence in New Zealand or Australia, who have been sentenced and have served their sentence, and actually in our system of justice and most systems of justice around the world, when you serve your sentence, you return to the community. That is the reality. So all this hysteria about there's murderers walking around, there's rapists walking around, actually, every single day we release from New Zealand prisons people who have committed serious offences. These people are in the same category. So let's not overblow this. Let's not suggest that somehow the public should be battening down the hatches. It is actually still a relatively small number compared to the New Zealand population, and the same sort of people and the same sort of conditions that happen in New Zealand. Yes, it's important that we have a commensurate regime in place, but let's not suggest that somehow the boogeyman has landed and it's the beginning of the end. We need this legislation, but I think some of the hysteria from some quarters of the media has been unhelpful. So with those words, Mr. Speaker, I commend the bill at second reading.